So welcome back. We're very excited to present the FTC's first ever panel on copyright issues, and we're grateful to have a distinguished group of panelists here with us today. Just briefly introducing everyone, going down the line, we have Eric Cady of the Independent Film and Television Alliance, Meredith Rose of Public Knowledge, Sean O'Connor of the University of Washington School of Law, Tyler Ochoa of the Santa Clara University School of Law, Keith Cooper-Schmidt of the Copyright Alliance, and Peter Manel of the University of California, Berkeley School of Law. So to kick things off, there have been a number of technical and legal developments over the past decade that have resulted in changes in how we think about copyright law and the role it plays in the promotion of innovation. And I'd like to hear from each of the panelists to start, which developments do you think are the most significant, and how have these changes impacted competition and innovation? We'll start with Eric.
Sure. Well, thank you to the FTC staff for the opportunity to participate in this afternoon's panel to share the experience and perspective of the independent film and television industry on competition policy and copyright law, both of which are very important to the Independent Film and Television Alliance. IFTA represents more than 140 companies in 22 countries, the majority of which are small to medium-sized US-based businesses, which have produced many of the world's most prominent films, including 80% of the Academy Award winners for Best Picture since our association was formed back in 1980. In contrast to the major studios, independents are completely reliant on third-party distributors from around the world. And copyright is the foundation for the financing and commercial exploitation of their films and television programming. Collectively, the independent sector accounts for over 70% of all films produced in the US each year. As producers of much of the innovative content that propels our digital economy, IFTA and its members are strong supportive of measures that promote competition policy, ensure consumer protection, foster diversity in programming, and choice for consumers. In terms of developments over the past decade, the marketplace has shifted to the internet, and digital rights are an increasingly important element of production financing as the online marketplace continues to develop and consumer demand evolves. While the internet creates important opportunities for expanded distribution, new audiences, new revenue streams for independents, it also presents the biggest threat to our industry, as online infringement is allowed to flourish without any effective means under current law to prevent or stop the introduction and rapid proliferation of infringing copies across the internet. The result is a distorted marketplace where rights holders are forced to compete with pirated content, often made available for free. Copyright infringement damages independents well beyond lost revenues by impacting their basic ability to secure financing and distribution. Like I said, independents depend on third-party distributors who, prior to production, contractually commit to pay a minimum guaranteed license fee in exchange for the exclusive right to distribute the finished product in their particular territory. Those exclusive license agreements are then collateralized to secure bank loans to complete the physical production. Online theft, which is often suffered on a massive commercial scale, severely threatens the balance of this creative and business framework, impacting the ability of these critical early investors to recoup their investment. More recently, the widespread emergence of streaming piracy enabled by devices and add-on applications is particularly damaging since they normalize piracy and bring illegal content into the living room through set-top boxes and other internet-connected devices, often which have sleek, user-friendly interfaces. While the major online platforms and service providers now routinely deploy enhanced anti-piracy protections with respect to their own content, and in the context of agreements with large content suppliers, they refuse to extend those enhanced services to smaller content providers. This discriminatory treatment creates a substantial barrier for small content suppliers seeking to use the internet to reach new audiences. The FTC should pay particular attention to the platforms and their discriminatory deployment of tools designed to protect content on their systems, as the minimum legislative requirements under the DMCA are no longer sufficient in today's high-speed digital environment. For example, in the case of Google, IFTA members report being offered only the option of continuing to send thousands of notice and takedowns with respect to infringing copies found on YouTube, or the option to monetize those illegal copies by allowing YouTube to place advertising on those copies and sharing only a fraction of that revenue with the content provider, rather than preventing the upload and further illegal distribution of those files. At the same time, the growth of online platforms has been prioritized as a matter of public policy over protecting consumers from traffic and illicit content, which has generated profit for the platforms at the expense of legitimate rights holders. With this backdrop, there is a growing and serious concern in the US and around the world about the lack of responsibility and accountability exercised by the major internet platforms toward the harmful and illegal activities taking place on their services. The ultimate result here is a toxic environment to conduct business and reach consumers. IFTA has long been on the record with regard to the competitive challenges facing independents in the marketplace, whether arising from the integration of major broadcast, cable, and broadband companies, or today with the extraordinary growth of a handful of online platforms, all of whom now produce and promote their own programming. Independents have limited leverage in negotiating for access, good placement, marketing, and revenue shares with these major conglomerates, and thus access to independent programming is under threat. The FTC should focus more broadly on the role of these intermediaries, their placement of advertising, and self-dealing with access to information, including consumer viewing behaviors. In the European Union, the Commission has already launched an initial investigation as to the anti-competitive impact of Amazon using data it's obtained from third-party merchants on its platform to unfairly advantage its own business. As further outlined in our written comments, IFTA joins the other representatives of the creative industries to call upon the Commission to exercise its broad investigative authority to examine how today's dominant internet platforms engage in practices that harm competition in the creation and distribution of copyrighted works, and in doing so, ultimately harms consumers. Thank you.
Thank you. Meredith?
All right, thank you. First, I want to say thank you to the staff of the FTC for organizing this and for taking a good hard look at some of the issues in intellectual property and how those impact competition, and also for obviously inviting PK to speak. I generally wanted to speak about the issue of copyrighted software and some of the ways that that has had an effect on both issues of consumer confusion and issues of anti-competitive behavior. Generally, I think we have been both legally and socially caught a little bit flat-footed when it comes to the role of software and ownership and how those two things interact with one another. Rather than recognizing that software has the massive potential consequences in our current legal system and potentially deserves its own framework, we have sort of shoehorned it into some combination of contract law and copyright law. Contract law, which is notably predicated on the idea of there being a negotiation, which there isn't in most software contracts, and copyright law, which is designed to respond to the specific pressures with traditional creative works, such as music, writing, art, et cetera, and isn't particularly well equipped to deal with something with the sort of hybrid creative functional nature of software. So there's kind of 3 points at which I think the rubber really meets the road on this, and I'd like to discuss them briefly. One is that nowadays we own very little as individuals. Generally, everything is, an item is mine only to the extent that I don't do anything precluded by the terms and conditions that are attached to the software that runs the device. And as softwares become embedded in more and more devices, this implicates more and more of the objects that we own, in scare quotes in many cases. This can include everything from your phone, which is a more obvious example, and your computer, down to your watch, potentially down to your refrigerator, if you have a smart refrigerator. Somewhat famously, if you follow the copyright 1201 hearings, down to your tractor, which is often embedded with software. You only are allowed to use the item. You don't technically own it in a lot of cases to the extent that you comply with the terms and conditions of the end user license agreement. And the moment you stop complying with those terms and conditions, you're in a violation of contract, which means that any subsequent or even current at that point use of the software constitutes software piracy. that becomes a copyright violation. And so essentially that, when you combine that with things like statutory damage potentialities, you have $150,000 for running a piece of software in a way that the manufacturer perhaps just doesn't like for whatever reason, without necessarily having a sort of legal or policy justification underneath it. And this runs directly up against a consumer understanding and expectations. We have a very specific, perhaps not specific, but we have a very general, very deeply rooted concept, both socially and legally, of what constitutes ownership and what I can do with something when I buy it. Very famously, Aaron Perzanowski and Chris J. Hoofnagel did a study on the Buy Now button, as made famous on Amazon, but they did a mock-up with their own site. And the results of what people thought they were getting when they clicked a Buy Now button were pretty astounding. 16% of participants thought they had the ability to resell the ebook that they were buying with a Buy Now button. 30% thought they had the ability to leave it to other people in their wills, which they did not. 40% believed they had the right to lend or give it away, which they do not. And more than 80% thought that they owned the work and could keep it indefinitely and could use it on whatever device they chose, which is also not true. The word buy has very different connotations than pay for access to a license, the terms of which may change at any time. Which is functionally what a Buy Now button is. Anyone who's on Twitter frequently enough, as I am, for one thing, I'm sorry. Two, you probably saw a viral story about a gentleman who moved, I believe, from Australia to Canada and found himself locked out of all of his iTunes movie purchases. So this is kind of what we're dealing with. There's this gap in expectation when the consumer comprehends his ownership and what software companies and platforms represent as ownership, which in reality is sort of this complex licensing schema. This has really large implications for downstream commerce on top of everything else. If I don't own the car, and I'm operating the software that is critical to running the car only under a license, what are my options for things like repair, replacement, modification or customization, resale? Many times the licenses prohibit or drastically restrict these common behaviors or artificially limit them to a few in-house or downstream approved providers. Apple is uniquely bad about this. I say this as someone who owns several Apple devices, but the ability to only get your Apple device repaired by an authorized Apple retailer is a problem and sufficiently stifles downstream commerce. And attached to copyright, we have sort of copyright-adjacent laws, such as the anti-circumvention provisions of Section 1201 of the Digital Millennium Copyright Act. And what these do, for folks who are unfamiliar with them, is 1201 creates a separate right of action for anyone who circumvents a technological protection measure that effectively controls access to a copyrighted work. You don't need to actually implicate the copyright in the underlying work at all. If you merely circumvent the digital lock on that work, that in and of itself is a separate violation. And this has been used somewhat famously in the example of John Deere tractors, to control who is allowed to repair your tractor. It came up every 3 years. There is a triennial rulemaking hearing that the U.S. Copyright Office engages in, where they issue exemptions to this. And it is a laborious process to secure one, and you have to argue them de novo every 3 years. But one of the examples that came up this year in particular, which I wanted to flag, was one in avionics, which is the computers on board airplanes. There is an FAA mandate that requires certain kinds of security compliance testing and certain results. I don't know what the exact schedule is, but the major manufacturers of onboard avionics computers have prohibited any independent parties from conducting any of the mandatory software testing that they are required to do by the FAA. And so to get these legally mandated tests done, you need to go to the in-house security penetration testers, who will only give you essentially a piece of paper that says thumbs up, in effect, and you can pay extra to get access to the actual data that they were able to get to. So we have plenty of examples of copyright and copyright-adjacent laws, such as 1201, controlling downstream commerce in a way that was not within the purview, certainly of the original design, frankly, of these laws. And all at the end of the day, this kind of just is evidence of this poor fit between modern software and the sort of legal framework surrounding it, and how we traditionally envision ownership, competition, resale, and issues like that.
Thanks, Meredith. Sean?
Hey, thanks. I want to thank the FTC staff for bringing me in for this. And I've been on many sides of this equation, so-called innovator side, content creator side, and a really important starting point is always that creativity and innovation go hand in hand. They're not necessarily in tension with each other, and so a lot of creators are innovators and innovators are creators. And so what we really want to be thinking about here is how do we have robust markets and how do we have free and fair competition? And I still use as a starting point copyright and other property rights, that when you have those, then people can enter into private market arrangements. So starting at that point, we need to look at some of the arrangements that are going on because we want to encourage this kind of innovation in business models, innovation in contracting, innovation in licensing, but we also want to make sure that those things are not becoming anti-competitive and that they're not harming consumers. I do want to scope my remarks here and say that I won't be covering data or actually software or industry-specific things like music, just because those are big rabbit holes that we could spend a lot of time on. And maybe in the discussion, we can go through that. I think the best use of my time here, because of my particular background, is making some distinctions and talking about how I view the world when helping clients and when doing research and looking at this whole innovation and creative nexus space. So let's make a core distinction, okay, between business to consumer licenses and business to business licenses. Okay, that's standard kind of management school, business school speak, but it just means that you have some things like we used to call EULAs, end user license agreements. Today you normally think of them as terms of service. It's all that stuff you click I agree on and you don't really read it, and we're not always sure what's going on with it, but those are effective. Now, within those, there's often copyright licensing going on, okay? Now, my remarks today are mainly focused on that copyright part because that's our panel here. And so if we look at that, the terms of service, the business to consumer, okay, now we want to think of some of the issues there. In a moment, I'll turn to the business to business, and those are less obvious to the regular outside observer. It's the contracts behind the scenes that businesses do with each other. So on business to consumer, I think the biggest question is, again, in copyright content, what's being done with my stuff? That's what we all want to know. We create stuff. Some of us do it as amateurs. Some of us do it as professionals. And then we enter into all these agreements online with a lot of the internet giant companies, and it's fun and it's awesome that we can get our stuff distributed, but we don't always know how those pipelines are working and where everything is going. We also know that a lot of consumers, particularly teenagers, young adults, are learning the hard way about that the internet is forever, and some of their stuff once posted kind of stays up there. So we need to think about that a little bit. Now, I'm not against a lot of the licensing models going on. And I also want to be careful to carve out the notion of contracts of adhesion, take it or leave it contracts. That's what a lot of these end user license agreements and terms of service are, but there's nothing inherently wrong with those. But you do sometimes want to scrutinize them a little more carefully. Okay, because of the fact that you don't often have real negotiating going on and people aren't deeply thinking about what's going on in the contract. So we want to look at it a little more carefully. A lot of us have heard about the mandatory arbitration clauses. It can be difficult. So if I start having concerns about where my stuff is going and do I have a right to get my content taken back down, if I dispute it, I'm stuck in arbitration, which may not work for a lot of consumers. The notion of rolling contracts, where when I do that first, I agree, I basically have kind of pre-agreed to changes that the other company will make. Now, it's true that there's some, as we teach contract law, we say consideration has to happen, but the consideration is simply that in exchange for you continuing to use the service, you then agree to our new terms. But a lot of times consumers don't even know that the terms have really changed. Okay? So we need to worry about that. We need to worry about the creeping differences in a lot of these contracts so that what may have been reasonable expectations for how your things could be used a number of years ago may be different now because a lot of these companies are kind of pushing further and further on what can be done with the content. And now that's what we all expect, right? We expect it'll turn up everywhere. What do we do about that? Also in an era of disruption where the mantra is ask forgiveness, not permission, right? So let's keep pushing the envelope and see what happens. So on the business to consumer side, just a couple of recommendations that might be worth looking into. Following up on the notion of right to be forgotten that's being explored a lot in the EU and other places, thinking about how to make it enforceable, that people can get the control of their content again and get it back out of these various systems when they want to and when they need to. I think perhaps, again, I'm pro-licensing, but discourage some of these, what I'll call perpetual licenses, with these vague assignment sub-licensing provisions. And this is going to feed into my business-to-business comments in just one moment. What goes, you know you're giving your content to one place, one of these social media platforms, but then can it leak out to other places? Well, of course it can, if you've agreed to allow them to sub-license it further, and they then can sub-license it out to lots of third parties. So maybe we also need to be thinking about guidelines and standards for those kinds of licenses, and also for thinking about enforceable public-private distinctions. We know that a lot of folks think that they can have a private zone with just their friends where their content is, but then sometimes it seems like that becomes public, and people are often surprised about that. Okay, shifting over to business now. We don't really know a lot about what's going on with the contracts among a lot of the leading, I'll call them so the internet giants, and a lot of the whole ecosystem of other companies that rely on them. So we know what I'll call the public-facing firms, the internet giants. We know that they have the business-to-consumer licenses in place. But in this behind the scenes, we know somehow it's linked back there to advertising and search engine optimization and data mining, okay? That thing where when you search for something at one point and then for the next week or so, I was looking for guitars recently, and then, every website I go to, even on my phone, little ads are for guitars, and it's kind of embarrassing. How do those contracts work? See, they have to be contracts. There's something going on behind that allows that stuff to happen. So I think that what we want to do as well is look at, is there any potential unfair leveraging of the companies that have the largest portfolios of the content, saying, look, if you want access to any of this content, then you need to then sign these business-to-business deals with us. And the final point, because I'm really running low on time here, is that as these networks of licensors are being put out there and created, are we also displacing some of the other regimes for open kind of content distribution like Creative Commons, which people could have some reasonable expectations about how their things were being distributed, now with essentially kind of private networks of sets of rights, and what are our reasonable expectations around that? So I think that looking at the behind-the-scenes business-to-business licenses are as important as looking at the business-to-consumer licenses. And I think that the FTC, using a lot of its longstanding practice of issuing guidelines on licensing, and particularly looking at distinguishing horizontal and vertical licensing, would be a really good use of time. Thank you.
Thank you. We're also joined by Peter Yazzie of the American University Washington College of Law. We've been talking about significant developments in copyright law over the past several years, and particularly those that may impact competition and innovation. And which do you think are the most significant?
Thank you. So when one could describe the relationship between copyright law and competition policy over the course of my professional career as 50 years of solitude, with two discourses occupying essentially the same policy space, but resolutely refusing to acknowledge one another's existence. As any former students of mine in the House will know, I've been predicting for many of those 50 years that there would have to be an eventual convergence, if not a collision, between these two lines of thinking. So I find the fact of this hearing and the fact that I was invited to participate in it very gratifying indeed. I think I'll begin by stating, rather than belaboring, some four propositions that seem self-evident to me, although there may be room to discuss them later on. First, that the copyright monopoly in non-rivalrous information goods is inherently anti-competitive by both design and definition. The second is that the commonly held assumption that copyright has some incentive effect on innovation, although not inherently implausible, is neither demonstrated nor perhaps demonstrable. On the other hand, we can show that follow-on creativity and innovation necessarily does require reasonable lawful access to pre-existing content or works in copyright jargon. And we can also demonstrate that as a historical matter, many of the most significant bursts of copyright-related innovation over time and space, although particularly in the US, have been closely associated with limited copyright protection, either as a formal or a functional matter for the information goods in question. In other words, although both the individual consumer and the general innovation climate benefit, we believe, from right-sized copyright protection, neither is likely to thrive in an environment of hyper-protection. And from that perspective, I want to make 4 points about copyright doctrine at this moment of convergence, and all relate to what I think are, in one way or another, urgent items, action items, or as the case may be, inaction items. The first two are about the importance of maintaining or nurturing certain existing pro-competitive features of copyright law, while the second pair relates to some features of that law that may now require reconsideration. First, the fair use doctrine. The general safety valve of the U.S. copyright system is more important today than ever before. Although it dates back to at least 1841 in one form or another, fair use has come into its own only really in the post-war period, and especially in the last 25 years. Under current Section 107, the doctrine is in a pretty good place now, both textually and jurisprudentially. Later on, I'd be happy if anyone were curious to multiply examples of how fair use promotes competition of all kinds. But for now, I'll simply say that in years to come, the doctrine must be preserved from both its enemies and its friends. Its enemies would like to water it down, and at least some of its friends would like to enhance its short-term clarity at the expense of its longer-term flexibility. Both temptations should be resisted. Another existing doctrine that stands in a very different place is copyright misuse. This is, as yet at least, an under-realized, underutilized doctrine. It's of relatively recent vintage, but it has enormous potential. It's been a wallflower at the ball of copyright for a while, but I think it may be about to come into its own. The doctrine, which could serve and occasionally has served to port competition policy considerations into the heart of copyright litigation, as memorably, for example, in the Practice Management Information Corporation against AMA case, is one that is worth watching, and especially for academics who care about I should say judges and academics who care about the competition copyright nexus to promote. Now let me turn very briefly to two copyright doctrines that I think in this moment have gone far enough off the rails to require some urgent reconsideration if this pro-competitive right-sizing of doctrine is to be achieved. One is, of course, the rules relating to statutory damages, which is presently constituted, consistently operate to discourage pro-competitive, good faith risk-taking by innovators. Over the last half-century, the relevant provisions of Chapter 5 of Title 17 have lost all semblance of a nexus with their original purpose, which was to fairly compensate successful plaintiffs in cases where actual damages were especially difficult to prove. Today, they serve explicitly punitive and deterrent functions, and they're deployed accordingly by rights holders, not just in court, but also in all kinds of pre-litigation skirmishing. The result, of course, is that small innovators are chilled into making risk-averse choices to the general detriment of all. Statutory damages may have a continuing role to play in cases involving out-and-out commercial piracy, but they have grown out of all proportion to their true utility and urgently need a good pruning. Finally, let me note that before it's too late, and it may be too late very soon, some of our basic assumptions about authorship and initial ownership of copyright could use a stem-to-stern reconsideration. We know that in years and decades to come, more and more copyrightable works, from databases to computer programs to art, will be produced by effectively autonomous intelligent agents, which themselves in turn will in many cases be the products of yet other AIs. Right now, we're not up to the question of how rights of ownership under copyright in such productions will be or should be assigned. The best guidance we have is that perhaps they might be allocated to the person or the company that was the first mover, so to speak, in setting the train of machine authorship in motion. But that is, for many reasons, a very unsatisfactory solution. The most important of those reasons being that it will, of course, or the application of such a rule will, of course, over time, have the effect of creating greater and greater consolidation and concentration of ownership where information products are concerned. And that's an outcome about which considerations of both competition policy and broader social policy suggest extreme caution. Thank you.
Thank you. Tyler?
So I think my comments will echo many of the themes that we've heard on the panel here, but hopefully with a bit of a different spin in a couple of areas. So the two things that I wanted to address were sort of abuse of end-user license agreements and artificial intelligence. With regard to the end-user license agreements, we see abuse in both directions. We see abuse directed towards copyright owners in some instances, and we see abuse by copyright owners in some instances. So Sean talked about terms and conditions in end-user license agreements that automatically assign ownership of a copyrighted work to the social media platform or have such a broad license that it essentially renders any type of commercial use available to that platform. You see this in lots of areas where people post things to social media or post photographs. Maybe they enter a contest for a photography contest for the best type of picture you can have of wildlife. And the terms and conditions specify that the user can do absolutely anything they want to do with that, right? So that's taking advantage of copyright owners who want to see their work reach a wider audience, but then the terms and conditions allow that work to be used for commercial purposes without any further consideration. Definitely, people should know what it is that they're signing up for. When they post things, people should have the ability to post things and have them disseminated without giving away all of their rights or most of their rights. The flip side of this is abuse of end-user license agreements by copyright owners. And copyright law is designed very differently from patent law. Patent law gives the patent owner an exclusive right to use the patented invention, although even there, under the first sale doctrine or the doctrine of exhaustion, once you've sold a machine embodying a patented invention, then you can continue, then the buyer can use it in any way that they see fit. But with copyright law, there is not even an exclusive right to use a copyrighted work. The exclusive rights of reproduction and distribution exist. The exclusive right of public performance and public display exist. But there's no exclusive right of private performance. One is able to read a copyrighted work as many times as one wants. One is able to listen to a copyrighted work as many times as one wants. It's specifically designed not to control individual behavior. And yet we see copyright owners using end user license agreements, terms and conditions, specifically to give themselves a right of private performance, specifically to control user behavior, so that persistent access controls, you can't necessarily listen to or watch this as many times as you want, but only X number of times for a particular purpose. You've got a copy that resides permanently on your hard drive, but you're only going to be able to use that for the next 5 years, and then it's going to go away. Or you have to enter some sort of download code in order to be able to use this copy further. And we see that both with regard to traditional media, digital copies of traditional media, and in particular with regard to software, so that you own a copy of software, but the software company alleges that you're the only one who can use that, and you can't even lend your laptop to somebody else and let them use it because they don't have a license from the software owner. I might add that even the term license itself is a bit of a stranger to basic copyright doctrine, which talks in terms of sale or other transfer of ownership or rental, lease, or lending. Those are the only two options under the public distribution right: sale or other transfer of ownership or rental, lease, or lending. And what you have is software companies and owners of digital content contending, well, it's not really a sale. You didn't really buy something, so you don't own it. But they're also not claiming that it's a rental, lease, or lending, because they know if they did that, the consumers would rebel against the notion. Instead, they use the ambiguous term license, as if they had the right to control anything you did with a copy that you owned permanently. So I think seeing that sale is defined in a particular way so that these abuses could be lessened would be very helpful. The second area of concern, I think, is artificial intelligence. And Peter mentioned one concern, which is we're going to see some type of artificial intelligence or machine learning generating copyrighted works. I want to look at the other side of that for a minute, which is how artificial intelligences are trained, because they have to be trained using very large data sets. And data sets, by definition, are often going to be copyrighted works. If you're training using large areas of text, you need lots of textual works which are subject to copyright. If you're training using a large data set of photographs, the photographs are subject to copyright. So in order to do research in AI, in order to train an artificial intelligence, one needs access to large data sets. Well, where are we getting those data sets from? The only people who have large data sets are typically large platform owners, large content providers. What are the terms and conditions on which those data sets will be made available to researchers? What are the terms and conditions on which those data sets will be made available to developers of artificial intelligence? Will they be licensed on a non-discriminatory basis? And so forth. So I think those are a set of issues that are worth considering. And related to that, we have the problem of bias in the data sets, because we see evidence that the data set you use influences how machine learning learns. So for example, when you're trained on a data set of photographs of white people, facial recognition works very well when you're recognizing the faces of white people, and works much more poorly when trying to recognize the faces of people with darker skin, because the artificial intelligence wasn't trained on that data set. So what can we do to assure that the data sets that are being used are non-discriminatory, are representative, and aren't building additional biases into the system? So those, I think, are issues that could be profitably looked at. Thank you.
Thank you. Keith?
I want to thank the FTC for inviting me to speak here today on the panel on competition policy and copyright law. Thank you all for attending and everyone online. My name is Keith Cooper-Schmidt. I am the CEO of the Copyright Alliance, a nonprofit, nonpartisan organization dedicated to advocating policies that promote and preserve the value of copyright. We represent the copyright interests of more than 1.8 million individual creators. Those are creators like artists and authors, performers and photographers, songwriters, software coders, and numerous other individual creators who make a living through their creativity. In fact, the foundation of copyright is built on the creativity and ingenuity of these people. The Copyright Alliance also represents the copyright interests of over 13,000 organizations across a spectrum of copyright disciplines. When most people think of copyright, they may think of the entertainment companies and associations that we represent, but copyright protection is crucial to so many more organizations, ranging from book, magazine, and software and newspaper publishers to organizations that you might not think of as relying on copyright law, like the NBA or the National Association of Realtors or the National Fire Protection Association. There's one thing that unites all of these individuals and organizations that are otherwise very, very different. And that one thing that unites them is their reliance on copyright law. It's copyright law that protects the fruits of their creativity. It's copyright that protects their basic freedoms, their freedom of expression, their freedom to pursue a livelihood and a career based on their creativity and innovation. It's copyright that safeguards their rights afforded to them under the Constitution. It's copyright that propagates America's culture around the globe. It's copyright that promotes competition and innovation. And it's copyright that is crucial to the success of the U.S. economy, as evidenced by the fact that the core copyright industries add $1.2 trillion to the U.S. GDP and employ nearly 5.5 million people. Now, I'd like to highlight one of those core industries, the software industry, because many people may not understand just how reliant the software industry is on copyright protection. No other country can boast a software industry as vibrant as the United States. And that is in large part due to our strong framework of copyright protection. Because most software is created through collaboration, copyright is often the only viable form of protection, especially where patent protection is uncertain following the Alice case. If copyright for software is diminished by overly broad applications of fair use or by denial of protection, the software industry will be forced to retrench to a closed model, no longer sharing code, and instead relying on proprietary contracts to keep code protected. That is a step in the wrong direction. The economic premise of copyright is that protecting property rights in creative works will promote innovation. This premise is reflected by the Constitution and supported by both the FTC and the DOJ in their report entitled Antitrust Guidelines for the Licensing of Intellectual Property. Somewhat contrary to what Peter Yazzie comments earlier, in that report, the FTC and DOJ confirm that the ability to license content can have pro-competitive effects for both the copyright holder and the licensee by increasing the value or utility of the copyrighted content and thereby encouraging the copyright holder's investment in it. Now, over the past decade, the creative community has embraced the internet and the growing capabilities of technology to make their copyrighted works more widely available and more easily accessible to the public. The result is that consumers today have a wealth of ways to access and enjoy all sorts of copyrighted works, and creators have many more platforms to reach their audiences and customers. All sectors that rely on copyright law have seen and continue to see great transformations due to shifting legal developments, evolving business practices, and new technologies. We have seen business models shift from download to streaming, from access on one device to many devices, from ownership of physical goods like DVDs to access to copyrighted works in digital formats like on-demand and subscriptions, and many more. Throughout these transformations, the one constant has been the importance of robust and meaningful copyright protections. Importantly, This includes the protections afforded to technological protection measures, or TPMs, which allow the creative industries to offer users and audiences these and other new experiences that otherwise would not be possible. Now, despite the success of TPMs, piracy remains a significant problem. For every technological advance that makes it easier for creators to reach consumers, there are bad actors one step behind that exploit these new capabilities through new forms of piracy. Piracy is the antithesis of competition. It threatens competition by allowing others to exploit works without compensating the creators, reducing the commercial value of the creator's work, and weakening incentives to invest to the consumer's detriment. While online piracy remains a persistent problem, it is especially harmful to small creators. PPA reports that 70% of all professional photographers have been victimized by copyright infringement multiple times in the past 5 years. Because the federal courts have exclusive jurisdiction over copyright claims, and federal litigation is so expensive and so complex, most individual creators and small businesses and micro businesses simply cannot afford to enforce their rights. The income they lose from piracy may seem insignificant to some, but to them, it's often the difference between staying in business or being able to travel to a location where they could create their next photo or their next book. For this reason, the Copyright Alliance is a strong supporter of legislation to create a voluntary small claims tribunal within the U.S. Copyright Office. While online piracy continues to be a problem, new threats, such as illicit set-top boxes and stream ripping services, have emerged to contribute to the environment of lawlessness that is hindering competition and innovation. Stream ripping is a process by which everyday listeners can rip a file from a streaming platform and convert it into a download file. Apps that facilitate this process are rapidly growing in popularity. The difficulty in combating this problem is that there are no infringing links or content to pinpoint and eliminate. Instead, stream ripping software targets legitimate streams and creates illegal reproductions. Another emerging threat is illicit streaming devices, or ISDs. The most prevalent ISD is the Kodi box, which is a legitimate media player that is easily configured to access illegal streams of copyrighted works that are available online. By pirating these works, ISDs harm not only copyright owners, but also impair competition by harming legitimate streaming services such as Netflix and Hulu that are licensed to provide content and increasingly produce their own works. They also harm the many creative professionals who contribute to these entertainment products by decreasing the revenue pie that serves to stimulate further creativity. As noted in a FTC blog post, many of these ISDs are often rife with hidden malware that can bombard users with ads, that can take over their computers, and that can steal their personal information. Importantly, these ISD distributors also often advertise their products as legitimate while at the same time promoting their illegal usage. This is one area where the FTC should be able to help. The FTC has extensive powers under Section 5 of the FTC Act to police and pursue instances of false and deceptive advertising and promotional schemes. To the extent these distributors of ISDs or stream ripping software advertise their products as 100% lawful or afflict consumers with damaging malware, the FTC should consider pursuing them for misleading and impairing customers and harming competition. Thank you very much.
Thank you. Peter?
Well, good afternoon, everyone. I wanted to widen the lens to think about the problems we will be facing in the coming decades. It's taken a while for copyright to hit the FTC's agenda, but I think it's going to be a recurrent issue, and trying to think through some of the more profound changes that have been going on in the content ecosystems. So I want to go back to the founding of the country and really the roots of our copyright system, this notion that we can, through markets, promote creativity, that by creating a system of exclusive rights, our government can mimic the way some other markets work in order to motivate people to create works. And I would say for much of the early history of this country, that model worked, that publishing began through the copyright system, was very much fed by the copyright system. And to this day, we still see the copyright system functioning in that way. But Elizabeth asked us at the beginning, what changes over the last decade or two have changed the way in which these ecosystems function? And there's been a rather remarkable shift that I think has happened without many of us realizing it. We can think about many content companies operating in the way that Eric's clients do, or Keith's clients do, where there are individual creators who create things. But now we're also in a world in which there are companies that are operating in the content space, but their modus operandi is not to sell works to consumers, not to use the copyright system in the way that it was understood. In fact, the most successful companies, or some of the most successful companies today, are companies that have developed social media and other platforms in which copyright plays a central role, but does not operate in the typical way. Now, in order to fully explain the story, we have to go back maybe a century to the birth of the broadcasting industries. And in order for that industry to take off, we needed advertising. Advertising was a way to enable companies to build broadcasting, and since there was no way to create turnstiles or other ways of paying, advertising came in, and for half a century or more, it was an essential part of broadcasting, which is also very central to the media and the copyright industries. But with social media, we've seen a shift, and that a lot of the use of the social media platform is actually not to serve in this primary function, but really as a data collection system so as to improve ad targeting. And this ad targeting is really a major shift in the way the copyright and the larger ecosystem function. So how would I highlight this shift? So it's not as though all internet companies in the content space are operating in the same way. Netflix, for example, harvests data to help them identify what would be good content projects to develop. And I think that in some ways harkens back to the way copyright has always been used. But when you think about Facebook or perhaps YouTube, that a lot of what's going on there is the content is being pushed out really to monitor user behavior. And so it fits into some of the other themes we've talked about how, contracts and all kinds of new licensing models are playing into this new world. And so I think it directly connects to the FTC in the sense that we're now really seeing how consumer protection is really intersecting with the copyright system, and that a lot of these phenomena, and I'm on the fence about what to do or even what to think about these things, but it's a dramatic shift in the way in which many companies operate. Their goal is to use copyright as really a data collection mechanism. And then they work with data brokers and other companies to better target ads. And then we get into what you might call the unintended or side effects of some of those. And I'll say the last election cycle was one of the side effects, that we found that the same tools that were developed for ad targeting were harnessed to very much influence democracy. And that's something that I would say is of great concern, and that I know it's a very sensitive topic, especially here in Washington, but it's one that we're confronted with, because now we've built tools that allow very effective targeting of ads, and the whole ad industry is not so much oriented towards providing information so much as persuading us, manipulating us. And so I think that these issues are now in play in a big way. The other thing I would say, and this is perhaps more of a paternalistic view that I have, but I'm brought back to the work of Thorstein Veblen and thinking about how conspicuous consumption is fed in our society. And I think we're now living through Veblen on steroids, that we've created through social media, especially towards vulnerable communities, we've created ways in which we are vastly reshaping the way in which people grow up in our country and in the way in which they experience both content and advertising as kind of served up together. The other place we see this is with embedded advertising, that in some ways as a result of commercial skipping, we've now created a content industry that's very much focused on bringing advertising directly into the products we create. So I'm really putting this out as food for thought for trying to think about the very large issues. I'll just briefly comment, and maybe we'll come back in some of the other issues. There's another interesting competition issue here, that one of the big problems we faced with the internet was the illegal downloading, and I agree with Keith and Eric that this was a big concern. But we partially solved that problem through competition, that as Netflix was able to create, and other companies, HBO Go, Hulu, have created very effective streaming systems, we saw a lot of people leave the illegal towards the legal, but we're now coming into another phase of this. And that's because we have so much fragmentation of streaming that we're seeing, yet again, a rise in illegal content because people don't want to subscribe to 8, 10 services in order to get everything they want. So I think that's an interesting competition issue that is relevant, and in some ways, you know, it's within the control of the industries, but it would require us to rethink antitrust law, because we, in some ways, want to create, as Spotify is doing in the music area, we want to create an easy way for people to gain access to a lot of content. But as we also want to have competition, that means when Disney enters the market, as they will in the coming year, we're going to see a tremendous amount of fragmentation, which will again stoke the fuel of the piracy concerns. Last but not least, and I can't resist, partly because Keith somewhat raised this issue, this idea that software is protected by copyright is a very, I think, easily distorted issue. And the Oracle-Google litigation, I think, highlights an important reason why we ought to be, we ought to keep on the FTC agenda competition in the software industry. Functional specifications are not the kinds of things that copyright protects. And the courts had largely resolved that issue, and now, because of the Federal Circuit's misinterpretation of Ninth Circuit law, we're now having to revisit that issue, and I think it's unfortunate. And the other problem we have is that the Federal Circuit doesn't sit as an independent circuit. It was supposed to apply Ninth Circuit law, and it didn't. And now, perhaps the Supreme Court will take the case. I'm not sure what they will do with it, but whether or not they do, I think that it would be, especially if the Federal Circuit law remains the same, I think it's a legislative issue now. It's a policy issue, and we should definitely keep that issue on the front burner, because platform competition and interoperability and functional specifications are essential to the kind of valuable competition that supports. And so I'm a fan of copyright protection for software, but not for functional specifications. I think it has to be very narrow. It has to be limited to preventing piracy. But once we get into how a machine works, we're in the patent realm. And that creates other issues that we talked about this morning. But I'm willing to say it's better fought there than in copyright. Thank you.
Thank you. And I'm sure you all have questions for each other. I know there have been a lot of different issues raised, but I just want to kick things off with a question about end-user license agreements, since I think a few of you touched on that issue in your remarks, particularly the gap between consumer knowledge and the actual terms of a particular agreement. And my question is, what can the FTC do? What can we look for? What further research can be done to better identify those types of arrangements that may fall into the anti-competitive realm?
I can speak sort of very briefly to it. Like I mentioned in my opening statement, there has been some research done on this, and it has followed, Aaron Przanowski did the research, and he actually the second part of the study, which I didn't get to mention, is that they proposed a kind of alternative to a buy now button, which had a labeling system, which clearly, it had a thumbs up and a thumbs down. Next to the thumbs up, it said, here are things you can do with this, and here are things you cannot do with this. And they found that that had a remarkable effect in increasing consumer comprehension of what they were doing. The scholarship around this thus far has mostly focused on just the fact that the phrase buy or buy now tends to create a high degree of consumer confusion. So I think they're, having not spent nearly as much time on this as some other folks, I think that there's probably some answers in, labeling requirements to some extent. It's certainly a place to look.
So I would say there's a tension. And the tension when you're practicing law is you have your clients want you to do a really simple agreement, simple license, kind of like here's what you get, here's what you don't get. And then every time you simplify, you kind of lose some of the nuances of the exact legally enforceable language. So that's a bit of a problem. I think the way you can kind of thread between those, though, is getting some standard adopted language as to what these kinds of clauses mean so that you know that you can do that sort of summary of here's the bullet points. But again, a lot of us who are writing these licenses are very concerned that if consumers only see the simplified in 5 bullet points, they're missing a lot of the nuances of what is really going on behind that license. So having something that is kind of approved, maybe FTC approved, as to what certain clauses mean, and everyone can agree, okay, so this gives me that right, this clause gives me that right, this clause does this clause does that.
Yeah, I would sort of push back on that and say that the amount of information that they're getting off of a thumbs up, thumbs down button is still more than they're getting right now because no one's reading the license agreements. So you're moving from, you're moving maybe only to 10 out of 100 points, but you're moving from 0. So it is a marginal, albeit perhaps not a sufficient step up. The other thing that, and I say this as a video gamer, there are a lot of cases in which violation of terms of service have led to essentially copyright claims for things that are fundamentally not copyright issues, but because the behavior revoked the license agreement, then it became an unlicensed use of the software. For things that are essentially just boiled down to developer preferences about user behavior. I think that there might be an answer in looking for ways to ensure that the copyright aspect of them, of these end user license agreements, are decoupled from other behavioral preferences that are expressed by the copyright holder and licensee, so that we don't have a situation where, if I found an exploit in my game of Fortnite that lets me be a great sniper, that using that exploit does not necessarily land me or my daughter, who is probably more likely to do this, on the hook for $150,000 of statutory damages.
So my point, though, is that you're not going to get lawyers to stop doing the full license agreement. I mean, FTC would have to do something really heavy-handed, like say, oh, private people, you can't do your own licenses anymore. And instead what we have is if you have some bullet points that don't accurately reflect what the legal language is, you can do more damage as well.
So
It's out of sync now.
I think there's been a very good model of what Sean maybe has in mind through Creative Commons,
Right.
where Creative Commons has, end user license agreements in legal language, but has summarized and provides a suite of options that consumers can do for, you can do this for commercial purposes or non-commercial purposes, with or without attribution and so forth. And by far the most popular of the Creative Commons license is the non-commercial with attribution license, right? Because consumers want attribution, don't necessarily want money, but sometimes they do, if there's going to be a commercial use of their work, they'd like to be able to share in that. The notion that approved terms and conditions that provide a suite of options to consumers, and also perhaps prohibiting some of the more onerous terms. There really shouldn't be automatic assignment of your entire copyright in a contract of adhesion, I don't think, right? That's just not something that should be permitted. That should be only allowed perhaps on an individually negotiated basis.
If I could add something, first of all, I want to associate my comments with Sean. I think he identified very clearly, very well, the sort of push and pull between the lawyers and trying to get all the terms in there and trying to make the agreements as simple as possible. I think in the Creative Commons example, you still even see litigation in the Creative Commons area with licenses. So there's still are certainly issues with people still not understanding what they can and cannot do, even with regard to those licenses. So I don't think they're that unique in that regard. I mean, if we're talking about consumer education, that's something we are, all for, that we want consumers to understand, what they're buying, what they're licensing, how they can use or not use the products. If we're talking about sort of mandatory contractual provisions or limitations, I think we're getting into a very different territory. So, a thumbs up on, if we're using the thumbs up analogy, thumbs up on education, but I think beyond that, I think we're going a little too far.
I'd suggest, returning to the original question, that although I think the work on the disparity between consumer perceptions and the realities of the licenses to which they agree is enormously useful, there may also be room for some expert study of the question of to what extent and in what ways end-user licenses in general constrict or undermine or revise the classic copyright assumptions about consumer freedom. Copyright, for most of its existence, has operated on a set of assumptions about what consumers can do, not only with physical objects they acquire, but also with the content of those objects. Some of those assumptions are memorialized in doctrines like the first sale doctrine or the fair use doctrine. Others are a little more inchoate, I think, but nevertheless important. There is room for someone, whether it is an FTC study or not, I'm unsure, I think, to look carefully and, if I may say, scientifically at the way in which the terms and conditions of the full range of available EULAs stack up against those classical assumptions about consumer freedom. Again, in the world of in the promising world of new business models, as it has been presented today, it may well be that overall, as a society, we want to reimagine the position of the consumer in copyright law to be a much more passive and a much more restricted and a much less creative one than has historically been the case. But we ought to know what we were doing, and we ought to do it self-consciously if it's going to occur.
If I could just add to one thing Peter just said, I think we have to be careful, though, with which you mentioned sort of historically and sort of classic set of assumptions about consumers, what they can do. And I think the one thing we have learned over the past decade, if not longer so, is that what consumers want to do and is changing rapidly. And that's why, the copyright industries, the creative industries have been transforming their business models over time. Like I mentioned before, moving from a download model to a streaming model, moving from a model which allows, access from just one device to many devices or in many different locations. And so that sort of assumptions is what consumers, that didn't exist, 20, 30 years ago, whatever, and now it does. And so I know the creative industries are responding to that. So I think we need to be careful about relying on too much about what consumers historically maybe want to, and recognize that there's also what they're looking for today, which is oftentimes very different.
By the same token, however, it's clear that consumers are, coming up are being rapidly socialized into a system in which they lack the same expectations about consumer freedom that previous generations had. In other words, it's a chicken-egg problem to some extent. Consumers will learn to be satisfied with what providers provide. And so I don't think that any more than classical assumptions about how copyright promotes markets are irrelevant today. I don't think that classical or historical understandings about the idea of consumer freedom are irrelevant either.
I'll just mention
that
that licensing has been around for quite a while, though, and I think we want to be careful about that. For a long time, musical scores to orchestras have been under what I always call the lease license. Physical copy is sort of leased, and then you get a license to do some performances. So I do want to be a little bit careful about what we say are sort of the classical senses of what the expectations are. There's a richer licensing history going back over time.
And realistically, I think we also need to cabin all these discussions by saying that the business-to-business and business-to-consumer models are very different. Presuming, even in the case of a relatively small business, perhaps in cases of all but the smallest of businesses, you're going to have some sort of more or less comparable legal involvement on both sides. I can certainly cabin my comments to the situation of an uninformed, non-expert consumer. I sort of use my parents as the meter stick. Sorry, Mom and Dad. That they don't, they are boomers. They grew up with certain expectations about the things that they use and what they can do with them. And that's kind of the model that I'm operating off of.
I would just add that there are players in this mix that we don't even know much about. There's a whole sector of data brokers.
Right.
And believe me, I've been trying to figure that sector out. And when Facebook gets information through your use of their site, and they say, we're not doing it, we're not going to use it in certain ways, putting aside the data breach and other problems that they've had, I think there's a whole layer of the economy that's not well understood, that's pretty well capitalized, that is, sort of operating, and I don't use the word troll lightly, but they are able to connect a lot more dots in our personal dossiers than we may realize. And, it's obviously hitting much bigger sort of political and democracy-related issues. But the FTC is potentially a place to look at that issue because it has to do with competition in some of the most important markets. And whatever agreement I have with Facebook, I don't know their agreements with the further, deeper state of data brokering. And so, and that's going to connect to Madison Avenue and the whole advertising world. And I just think that we ought to know as a society, we ought to have transparency about all of these different layers. And I think the FTC is one of the few places that can do that.
I think this is the B2B issue again, and what's critically important is to look at some exemplars of it. When you have the Facebook or Google, you can log into other sites, and then there was a hack of that, and that was problematic, but people are focused on, oh, my other sites may have been compromised, but to me as a transactional lawyer, I'm kind of curious, what are all those deals, and this is what Peter's talking about, going on behind the scenes? I have some questions about whether there's some leveraging of one asset class off another. So one purveyor of social media that has a lot of content can say, well, you get access to this content, third-party data company out there, if you then give me access to something you have. We do some exclusive deals behind the scene. So that's what I was trying to map out again, and FTC is perfectly situated for this. Looking at exclusive versus non-exclusive licenses, looking at the classical horizontal versus vertical. Are you tying up markets? Are you tying one sort of commoditized thing to another?
So I'd like to push back on the notion that consumers are behind the transition from downloading to streaming. I think content providers are largely behind the transition from download to streaming because they want to get paid on a regular basis every month rather than giving you something that you can own forever. And, I think, consumers accept streaming on the basic notion, well, I'll be able to access this forever. And then they get really upset when Netflix no longer has access to certain types of works that they previously had been able to have access to. So, and it goes back to the notion of, what does buying something mean? But basically, I think we have a consumer preference for, I would like to be able to have this forever, and we see notions of ownership just disappearing in a purely streaming society.
So I think this is a good time to jump in with our next question, because you've all talked about a lot of sort of the tools that the FTC has, and I think, much like you said that this is one of the first conversations of antitrust and copyright, this is the first conversation I've had when I've been able to talk about our data broker study and our IP licensing guidelines. And I think that, one of the things that I'm thinking about as you guys are talking is what are our tools? So in the licensing space, we don't traditionally say, here is your license. We say, you parties should engage in your licensing behavior, and here's what you can do to be within the antitrust guidelines. So with that sort of background in mind, I'm curious to hear what future solutions you think that the FTC or other government actors can engage in to promote innovation in the copyright space. And we've talked about some of the FTC's tools in looking at our enforcement work, our policy work, and our research opportunities. So are there specific examples of enforcement actions that the FTC should look out for? Do you have suggestions with respect to legislative change? And Eric, maybe I'll start with you.
Sure, thank you. And just in terms of continuing to innovate, from IFTA's perspective, legislative solutions are required to address the problems associated with copyright infringement, especially as it becomes more sophisticated, particularly online. Our enforcement strategies and laws must adapt accordingly. And to ensure that copyright law keeps pace with the technological advances, IFTA offers two key legislative changes. The first, to classify large-scale unauthorized streaming as a felony to effectively deter online infringement and provide an important enforcement tool to pursue those who do the most damage to independents and their authorized distributors. So under the current law, streaming and downloading are exclusive rights of a copyright owner, but they're treated differently in terms of the criminal penalties for the violation of those rights. A violation of the public performance right, streaming, can only be charged as a misdemeanor, whereas unauthorized downloading, a violation of the exclusive right to reproduce and distribute, may be punished as a felony. This is particularly important in today's marketplace where, as we've learned, streaming is becoming the primary model for how consumers consume audiovisual programming. Second, IFTA would recommend updating the 1998 DMCA to provide for notice, takedown, and stay down to incentivize all stakeholders through safe harbor to effectively and rapidly deal with the damage of online infringement, especially in the most egregious cases of pre-release theft where there can be no legitimate copies available online. Today's now common technology is employed by major platforms where they can identify a specific digital file after a copyright owner provides notice of a digitally watermarked or fingerprinted file. They can do an exact match and ensure that those copies are no longer proliferated online, especially on their systems.
Well, thank you. Does anyone else have anything they'd like to add?
So I want to respond to Eric because I think he highlights why we've made so little progress in amending the copyright statute. That I've sat through, listened to all of the hearings that the House Judiciary Committee held, and each session involved people who were polarized on these issues. And now let's just think about what's been said on this panel today. I mean, Peter Yazzie hit the nail on the head. Statutory damages make absolutely no sense in the way they're currently being used. They were designed to help ASCAP go around and police, public performances in bars and restaurants, and now, it can create, a massive chilling effect on all kinds of players. And what I would say is that we could start having, I think, a conversation that might lead to legislation by just walking towards the middle on all these proposals. I mean, I think stay down makes a lot of sense, but not with massive statutory damages. I mean, I know Google and other companies like to say that it costs a lot of money to create these filtering systems that they deploy, and that would chill small companies. But in fact, Audible Magic and other companies license those technologies. And I think the FTC could easily do a study just to show that you don't have to build Content ID to create a new service that has, peer-to-peer and other capabilities built in. You can license those technologies. But I think in order to get anywhere, we have to take off the table that you would be potentially hit with extraordinary damages. I mean, small claims court could be a good solution for dealing with some of these issues, but we have to move towards sensible remedies. I mean, look at the Viacom case. I mean, 79,000 works times $150,000. I mean, there's over $13 billion. Now, when I asked the Viacom lawyer, he said, no, we're only asking for $1 billion. But in fact, you know, $1 billion was kind of laughable because they benefited from YouTube. And, you know, I learned about The Daily Show from YouTube, and then I started watching it. So I just think that you're exactly right, that the DMCA is out of date. But I would ask you and Keith and others in the industries to just start looking at the middle and try to talk with, you know, I think Google could easily come to the table if people were willing to put statutory damage and other things out there. So I agree with you that there are problems that are fixable. I think that the problems, though, have to be balanced, and none of the discussions in the public have really tried to do that, and I just think that's where we ought to be right now. And you know, I think if this panel were to sit together for dinner, we could probably come up with a really nice solution.
If I could jump in here, so I love that last line Peter said, and I just wish it were true. I think if we were to sit down, I think we would go down the line and define the middle. I think we'd all have different definitions of what that middle looks like and what it is. And so I'd love for that to be the case, and would certainly support that. But you know, I love what Peter said also about the small claims tribunal. You know, we're talking a lot about big guys and big lawsuits here, whether it's the Oracle versus Google case or the Viacom case or what have you. But you know, I have to admit, I'm really concerned about the little guys here. It's that's why we've been supporting the CASE Act, HR 3945, which would create a voluntary small claims court in the Copyright Office, because it's these little guys that are granted copyright rights but have no remedies. They have no way of enforcing those rights. And what's happened over time, especially over the last decade plus, is that these small creators, these small businesses have become disenfranchised by the copyright system. And as a result, they no longer are registering their copyrighted works. Because it doesn't make sense. The primary incentive, the primary reason to register your works with the Copyright Office is to be able to sue. And you get a lot of benefits associated with that, but they can't afford to sue. They can't afford to hire an attorney and pay what on average, I think $350,000 it costs to litigate a copyright infringement case. And so that's a problem. You know, patents and copyrights are indifferent in this regard. You have no rights to your invention until you go and get a patent. Copyright, you have those rights, and what you get from registering is the ability to sue, which these little guys can't do anyway. And so that's created more sort of a ripple effect. Because these small creators are not registering, that the Copyright Office's database is becoming incomplete, if you will. It's made up of all the little guys, the big companies and the big organizations and the big creators who can afford to register on a regular basis, or at least register more easily. And the problem is you've got people who are looking toward that ownership database to try to license copyrighted works, and that hurts both commerce and competition. And so for that reason, we think the CASE Act that would create the Small Claims Tribunal in the Copyright Office would be a huge step forward. It's not going to solve all the problems, but it would solve a lot, and it would give these creators, you know, who are disenfranchised now, they would give them some faith in the system, and they would begin to start registering once again. So I also just want to reiterate what Eric said also about the idea about this disconnect between you know, willful, egregious acts of downloading being a felony under the law, but when it comes to streaming, which is where, you know, the new business models are certainly moving, if not have already moved, is simply just a misdemeanor, and that just doesn't make sense. The law has not kept up. Criminal penalties for copyright infringement should not differ depending on whether a work is made available to the public, to download or to stream. And given the popularity of streaming, misdemeanor penalties are simply not sufficient to deter those large-scale infringers. The IPAC has supported legislation to fix this problem, and we support the IPAC in that regard.
And I just want to jump in at the end with a comparatively very small fix that I would like to suggest, which is, and I believe this would take some legislative action to formalize, but in the triennial 1201 anti-circumvention exemption hearings that the Copyright Office offers, they currently do it in consultation with NTIA, but over the last few rounds, we have seen more and more issues of competition and downstream commerce control coming up, and I would like to see the FTC become involved in that process, if nothing else, through either the availability of a formal referral mechanism or something similar to that, because as I said, as we see more and more softwares embedded in objects, we have seen more and more instances of companies sort of using 1201 to impact other areas of commerce outside of the initial production. And I would like to see the FTC have some kind of role in helping to consider those questions.
If I could mention, I think it's a terrific idea. I'd mention two other areas in which it seems to me that an attempt to come to the middle of the one of the kind that Peter describes would be interesting. And one is, in fact, this discussion of small claims tribunals that Keith has mentioned already. It has tremendous appeal and obvious advantages. And at the same time, I think there are those of us who are concerned that a small claims trial format might not be one in which the full range of defenses and exceptions available to copyright defendants could be easily or successfully invoked. So rather than line up for or against the small claims tribunal format, it might be interesting to actually talk candidly about those competing aims and those conflicting anxieties. An area in which legislation would certainly be necessary, but which I think is worthy of discussion now in light of all of the talk that we've had today about licensing, is the question of whether there are any consumer freedoms that are historically associated with copyright law that should not be waivable in an end-user licensing agreement. Should the fair use doctrine be waivable in gross in an agreement, for example? And that, I think, again, it's a tough discussion, but it's not actually a binary question. It's one in which there may be a middle ground, and it would be an interesting conversation to see if it could be arrived at.
So I'll be a little bit of an outlier and just say, I think, and this is obvious to the FTC, I think, the jurisdictional issue really is, I think that we're kind of varying on this panel now at the moment too, talking about substantive copyright law, which would be a great other panel, and we could really take a lot of time on. I'm refraining from doing that just because I think the FTC has been, and it's most helpful over the years to me as a transactional lawyer, with the guidelines about what's appropriate for licensing. I remember things where, more on the patent side, but if you, you license someone a patent and then you don't have to, you're not obligated to grant back, any of the inventions that you come up with. So this may get less exciting in some ways and less sexy, but this is the stuff that is incredibly important. I'll just toss out a couple of ideas again. This notion of maybe thinking about issuing guidelines discouraging these, what I'll call the perpetual licenses with vague assignment sub-licensing provisions. That's what lets everything just go perpetually through the data networks and lets you lose control of your stuff. I think that it's incredibly important to maybe issue some guidelines about enforceable private-public zones. I said this at the beginning, but let me just make a little more clear what I mean from that. A lot of us feel like we've been told that we have a private zone where we can just put our content up available only to a closed network of friends and associates, and then lo and behold, it gets disclosed much more broadly. That's a problem, I think, and this goes to, in some ways, the heart of contracts themselves. Are you getting what you thought you were getting?
In terms of what the FTC can do in enforcement, I think perhaps the single most useful thing the FTC could do was what Meredith talked about with regard to embedded software, is, trying to use the embedded software in a device to give you exclusive rights to be the one to repair or fix or service that device. That is a recurring problem. Section 117C was designed to address that in part, but it hasn't solved the problem because of 1201. That's just an obvious antitrust violation. It's an obvious tying arrangement. And, just to ensure that, because there is software in a device, doesn't mean that you can prohibit other people from being able to service the device.
So switching gears just a bit, Peter Yazzie mentioned the importance of the doctrine of copyright misuse, and we'd be interested in hearing whether you have any examples of copyright misuse and how the law would apply, and maybe other panelists have examples as well.
Well, I do think repair of devices with embedded software is the classic example of copyright misuse that could be addressed by the FTC. Another one we see in the Disney Redbox situation, tying a digital copy to ownership of a physical copy, where they should be able to be transacted separately.
So on the issue of, I don't want to go too deep on this, but in the issue of embedded software, I mean, that is an issue that has come up at the Copyright Office in the context of their Section 1201 rulemaking. I know that they are scheduled to come out with a new rulemaking decision, I think either later this week or next week or sometime very soon. So at best, it's sort of premature, I think, to talk about these issues, because this process, the rulemaking process, is an evolving process, and the Copyright Office has certainly tried to make it easier for those who are seeking exceptions, things like automatic renewals and things like that. I think certainly there are a collection of statutory exemptions in 1201, as well as the triennial rulemaking exceptions that ensure that the 1201 process does not sweep too broadly. So it's very likely that these issues may be sort of non-issues, if you will, moving forward.
That may be true, but I would also remind the FTC that they played a tremendous countervailing force in the patent field. That, the Patent Office is a little more sort of focused on the property rights orientation, just as the Copyright Office may be inclined. And because of the competition overlap, going back to the mid-90s and certainly through the whole battle over patents, I think the FTC is now, in my view, a very important player, a counterbalancing player. And so, just having a way of interacting with the Copyright Office and being able to provide guidance on what you see, because they see different parts of the elephant, you see different parts, and in that sort of combination, we get a better overall balance in our law.
If I might, I'd second what Tyler had to say about the potential importance of the Redbox case, which is, of course, ongoing, with respect to the future of copyright misuse, because the district court's interpretation of the doctrine in that case is a broad rather than a narrow one. It's not limited to the kinds of tying or the kinds of tying situations that have been the classic locus of the doctrine, and it bites specifically on this question of unreasonable contractual limitations on consumer expectations with respect to licensed goods. That is the very essence of the district court's attack in the Redbox case. Now, what will survive as the case progresses is a different question, but it isn't too soon, I think, to begin investigating from an enforcement perspective whether the vision of copyright misuse that the Redbox court articulates is one that should be pursued.
I think two issues. One, with the embedded software, that's, again, I think just a topic that is really much bigger than we could do today. I think if the FTC wants to get serious about that, it has to do a whole really kind of panel session on thinking about that. It's a really deep issue. On, Redbox, I think, and this is where sometimes I'll sound like I'm going in two directions, but I'm a big fan of innovative business models. And I think that, we do have to be careful about when we're looking at Disney providing content and basically saying, well, look, here's a way you can get two things of content at one bite. It goes back to this lease license model I said has been around for a long time. You lease or essentially convey under impermanent basis some physical object, and then you give some license rights. So it's not really that different than what's gone on before. And so then the question is whether people can just try to circumvent that. So I think that's an issue we need to be careful about.
Yeah, we've come through this digital revolution. It's obviously going to continue, but many of us on this panel grew up in an era where we owned records. We joined record clubs, which is, a thing of the past. And for my kids, I didn't want them growing up pirating, so we did iTunes. We spent a fortune on iTunes. And now we don't touch our iTunes, and we don't care about our iTunes because we're all on Spotify. And I don't think it's necessarily a wrong thing to not, Spotify will evolve. There are obviously going to be important governance issues in how that platform works. But the beautiful thing that it has brought about is that younger people are not viewing music as free anymore. They're joining services, they're participating in the market, and the celestial jukebox is starting to work as we had all hoped. And also the data side is pretty good because you get paid based on how people are using music rather than just some, Nielsen or other method. I mean, you have actual good data, and I think for people growing up today, the main problem, though, in that market, as I've tried to communicate, is that the major record companies are able to dictate the terms on which money is distributed, because no one would join Spotify without having access to the full catalog of the major record labels. So universality, I think, in music is a very important feature of an ideal system. But I think, as with the Music Modernization Act and other things, we're starting to view this as less of a free market, as more of a regulated market. But we could go back to the goals of the original copyright world, which is that we want that money to flow in a balanced way to the creators. So that's a sense in which I hope the Copyright Alliance would support me. And I worry that because of the legacy catalog, the major control in that space is still dictated by, 3 or 4 music labels. And how that, they've, Sony, for example, is giving some of the money that they earned from the Spotify, IPO to artists. But I think sort of for me, that's the health of a copyright system, is money getting to the creators in proportion to value. And, it used to be that record companies did a lot of value. They don't do it anymore. And yet they dictate the terms on which an independent artist comes into Spotify. So it's a very big issue. And, but I think the film side, what Eric's talking about, is actually a different market. And I was interested to hear how he viewed some of those issues. He's worried about Netflix, but in some ways, Netflix and HBO and the other companies are creating competition for his clients' products. And so making sure that market worked well could be very good for filmmakers. And I see the world as being, copyright is not monolithic, and so we have to look in these pockets. But music, I think, has improved dramatically in the last 5 years. Film and television is getting better, long-form content. There are a lot more people producing very valuable stuff that people are paying for. But I think being aware of how network effects are going to continue to operate in these fields and how power is allocated is ultimately going to determine how well the copyright system functions, how well money gets down to people who create things that other people value.
To sort of piggyback on that, holding up the music industry, I think, is it's certainly not a determinative example, but possibly an illustrative one. The music industry is governed largely by highly opaque contracts. Non-disclosure agreements are pretty endemic within the industry, and so this leads to asymmetries of information all around. And I cannot speak for artists as someone who is not one myself. I will, name check groups like Future Music Coalition, which does a lot of work on this, and that the money flows are intensely opaque. The amount of money that given streaming services pay out to record labels is opaque, and frequently the existence of a non-disclosure agreement is a precondition for any record label who wants to enter into these contracts. And so these things are purposefully obfuscated. This can create problems on the artist's end with asymmetry of information about what compensation rates are among artists. And one of the places we see this most endemically is in the exercise of termination rights, which are the statutory rights that were made available. They were created in 1978, and essentially what they are is the ability of an artist to revoke a license that they have issued for use of their creative work 35 years after that initial license was issued. The first batch of these really became ripe in 2013 en masse, and everyone kind of held their collective breath to see what would happen, and it was a big fizzle. There has not been much successful exercise of these termination rights, and the attempts to exercise them have largely been litigated, and they have been settled under non-disclosure agreements. And so there is this sort of endemic use among the industry, and while this is not necessarily this is partly a problem tied to copyright because termination rights are tied to copyright. I think a lot of the problems we've had in systemically addressing inequities that stem from these industries has been tied up in this truly amazingly pervasive use of non-disclosure agreements and lack of information flows. And it makes it very difficult, not only just as someone who is curious about the market, but it makes it extremely difficult for policymakers to craft any meaningful policy around these issues, especially when you're relying purely on self-reported numbers coming from major industry players who have their own interests to serve by crafting the data that they give you.
Thank you. And unfortunately, we're running short on time. I think we have time for everyone to make some final remarks. Eric?
Sure. So I think I would just add a reminder here that content fuels much of the platform innovation that we've discussed today, and would reiterate that as a matter of public policy, the consumer interest requires wide access to an ongoing supply of the creative content, from major blockbuster films to the diverse and unexpected productions from the independents. The unfortunate commercial reality here is that a few major online platforms and distributors of content hold market power that is unbalanced to the detriment of program suppliers and consumers. This reality, combined with a lack of meaningful platform responsibility to avoid illegal content, means that the FTC must be even more vigilant in its efforts with respect to competition, consumer protection, and their relation to copyright law, and we urge the FTC to make legislative recommendations in that area. IFTA looks forward to continuing its participation on these important issues. So, thank you.
Yeah, I think I just want to reiterate, fundamentally consumer well-being and consumer freedom is not just tied to freedom to access and consume content. It is tied to certain statutory limitations and exceptions in copyright. It is tied to certain freedoms to not only consume content passively, but to use content in forms of commentary, parody, transformative natures. And I think we tend to lose sight of that while the market has grown to accommodate passive consumption quite nimbly and quite pervasively, the trade-off has been that we have started to lose the immediate ability to exercise these other consumer rights that have been enshrined in the law. And the place where, again, I come back to harping on it, the place where we run into this perhaps most frequently is in the very fundamental concepts of ownership and how those have been undergoing or not undergoing a paradigm shift by the pervasion of consumer embedded software. So I thank the FTC for holding the panel and also for inviting public knowledge, having consumer voices on it. And hopefully, I look forward to seeing where your inquiries lead you.
So in my final remarks, I would just say, to reiterate again, that free and fair competitive markets, goodly competitive markets for creative works, are based on strong property rights. We start there, and then people move into the market. It's unfair if people have to negotiate against free, so I think we could spend a lot more time on the music industry, where things are just, if it's available for free out there, then you may freely come to a negotiation, but that's because you're competing against yourself in what the rates that you're trying to set. I think the transparency is something I think we all might agree on the panel, that there needs to be more transparency across this, especially with the data and what I'm calling these kind of behind the scenes, business to business deals that are going on. And then finally, just once again, I think this is a great time for the FTC to continue its research and issue some updated guidelines, particularly for how content is used in this new digital age.
I think one pretty clear point of consensus on the panel is that one measure of the health of a copyright system is the transparently available evidence of the meaningful flow of economic returns back to individual creators. But that's not the only measure of the health of a copyright system. As Meredith has suggested, the longer-term health of a copyright system, the ability of a copyright system to fulfill the purpose of promoting the kinds of cultural progress to which Article 1, Section 8, Clause 8 refers, depends also on mechanisms both in the law and in practice around the law to assure the continuation of consumer freedom to recreate. And that, I think, is where the new business models, the limited access models wrapped in end-user license agreements most threaten the health of our copyright system going forward.
I think I'd just like to point out that we have to be very careful because copyright owners are not monolithic. There are just lots and lots of different types of copyright owners, ranging from, so you have a lot of people that just want to post stuff on social media and on YouTube. Individuals who create content own copyrights in their content. They're primarily interested in credit. They're not primarily interested in money, but they don't want to be taken advantage of. If their stuff is being used commercially, they'd like a share of it. Then you have individual creators that are trying to do it for a living, that are trying to, individual photographers that want to be able to make a living from doing photographs, perhaps individual songwriters or singers that want to be able to make a living from their songs or their performances. And as Peter said, they have to live in a world where the rules are largely dictated by the large corporate copyright owners. The 4 major record labels make the rules for the music industry, and people who want to make money in that space have to live by those rules. Photographers, Corbis and Getty make the rules for the photography industry, and other people have to live by those. So trying to correct that imbalance of power between small individual copyright owners and large corporate copyright owners might be a useful focus.
So this is supposed to be a survey panel, and we certainly did do a survey. We covered a whole bunch of different issues. I know we're going to be filing written comments, and so it's just not possible to address all the issues that came up here today on the panel. But I do want to talk about one, since there seems to be a theme running down the table here about the health of the copyright system. And with regard to the health of the copyright system, what really hasn't been focused on enough here is the adverse effects that piracy has on competition. And I'm going to give one example here, or maybe two, but and try to do it pretty quickly. But in 3 months in 2015, Disney sent 35,000 takedown notices directed to illegal copies of Avengers: Age of Ultron, which was still in theaters at the time. Those were sent to one single site. That's more than 10,000 notices a month, more than 300 a day, directed at a single movie on a single file hosting site. Similarly, over a 3-month period in the spring of 2015, Fox sent more than 57,000 takedown notices to a single file hosting site for the film Kingsman: The Secret Service. That's 19,000 notices a month to one site for the same movie. If the DMCA was working as intended, one would expect the notices on the site to the site to decrease over time, yet we see the opposite. For instance, in the Kingsman example, on April 30th, Fox sent 697 takedown notices. On July 21st, 3 months later, it had to send 881 notices to the same site for the exact same work. In no universe, whether it's the Marvel universe or any other universe, is this an effective way to deal with piracy. This is just not a healthy system from the piracy standpoint, and something needs to be done. I'm not suggesting legislative change, but perhaps, we're a big supporter of voluntary initiatives and voluntary measures to promote competition and protect consumers, and we would certainly support the FTC playing a role in that.
I see we're at the end of our time. I'll just say that this was a great beginning, a great first date, and I hope there are many more.
Thank you. Yes, I think it's been a productive discussion, and please join me in thanking all the panelists.
So since I'm already sitting here, I'll do the closing remarks from here instead of standing up. But I just want to give thanks to Elizabeth and John for their moderation today. Thanks to the panelists for covering almost every issue in intellectual property and copyright law. You've clearly given us a lot of work to do in terms of going back and digesting the transcript and understanding what we've learned, both today as we prepare for tomorrow, when we will begin at 9 a.m. with Drew Hirschfeld, the Commissioner for Patents, looking at patent quality, patent litigation, trade association issues, and economic issues, closing with Commissioner Slaughter's closing remarks. So both in preparing for tomorrow, but also in preparing for what we're going to do going forward. And, I'm very happy with our inaugural copyright panel, and I hope that we'll be able to continue to work together. Thank you. And thank you, everyone. Have a good evening.